Justice Nancy Baraza, retired judge. You are very critical in the realization of the 2010 Constitution. Kindly let us know the key contributions of the Constitution and any other laws in ensuring more equitable land ownership in Kenya.
Thank you very much, and good morning, everyone. And so when we got the Constitution on the 27th of August 2010, as women, we said, hallelujah, because we have all those progressive provisions that empower women in terms of equality before the law, in terms of provisions on equal access and the control of property. Njoroge has just mentioned Articles 40 and 60, 61, etc. We have provisions, Article 10, very robust in the protection of the marginalized, etc. We have Article 48, which guarantees access to justice, and many other provisions. The Bill of Rights, I chaired the thematic committee at the CKRC, which produced the Bill of Rights. And the Bill of Rights went through, it was never contested, even at the harmonization stage. And so our contribution is there. So we have a robust constitution, but I started off on a sarcastic note because if you have been following what is going on at the GBV anti-femicide proceedings that we have been getting from the public, 40% of the femicide cases are as a result of land. So, and good I'm not surprised that it stands at 1%, but they are facing death. And that's why, Justice Angote, I think you are on my mind, because we got horrific submissions, especially in a place called Kilifi. Women get to 60 and there is a gray hair on your head, you are now a witch. And they ban you, they banish you. I hear there is a place under the bridge, I don't know, Judge, if you ever, where these women are marooned because they can't here, now you become a witch, and the society condones it. You now they believe you are a witch. Connect twin deals of the in respect of women and especially in access and control of land. Thank you very much.
Thank you very much. We will leave it there. Thank you for that contribution. Very horrific findings. Professor, please. Please weigh in on this issue briefly.
Okay. Well, thank you. Well, I would agree with Judge Baraza about equality provisions. I think that's, in my view, one of the most progressive anchoring aspects of our constitution. But in terms of land and women, there is an animal in this country we call ancestral land. And I think a big problem is in terms of how the rights of both women in the context of mothers and daughters is interpreted in terms of rights of use. Access is often not an sorry of ownership of ancestral land is problematic. What happens to a woman when she is widowed? You hear of stories where land is now up for subdivision and you're told to even move your graves. And if you move your husband's graves, as Professor Mbote says, even identity is an issue. You even find a situation where the husband had insisted on the property being registered jointly between his wife and son. When you ask, he says, well, nikikufa mali itaenda kwao. So that's a big challenge when it comes to ancestral land. And then there is another creature of law known as a land control board. In Kilifi, where Dr. Baraza is talking about, LCBs are approving the outright sale of 30, 40, 50 acres of land, the entire portion of ancestral land that somebody has, without regard to the consequences in terms of both constructive and actual landlessness. And this is a real problem. And finally, on that issue, is that often dispute settlement concerning ancestral land, whether in terms of mediation or otherwise, the vendors at the chief's office is dominantly male. And not just dominantly male, is in the category we often call of their hook and approach to interpretation of even customary rules is perpetuating even just the of inheritance, etc. And I would think, and it's a point to the judges in the room, that we've got to find a different jurisprudential approach to deal with ancestral land, because you may say in some parts it's getting finished, but in other parts of the country we are just getting started. And I think we look, ancestral land is really ripe for trusteeship, as Professor Mbote was saying, but it's also a very big contributor to the domestic violence and gender-based violence that Justice Baraza was talking about. Thank you.
Now that you're talking about jurisprudence and what the courts can do, perhaps we can hear from Lady Justice Possibor what jurisprudence is coming from the courts in terms of equitable land ownership.
Thank you very much. As I mentioned earlier, most of the decisions are coming from the High Court, Court of Appeal, and all the way to the Supreme Court in terms of matrimonial property and also in terms of succession. And I think the case of Mary Kangara comes to point from the Supreme Court, where, of course, we've always talked about, is it Echaria versus Echaria? It still remains good law, be proved. But the beauty is that the contribution is not just the documents showing the circle loan that you took to contribute to buy the materials that went into the roof, as Professor Ali alluded to. So they're also taking into account other contributions in terms of, I mean, if it was land that was bought jointly, and then the woman's, the wife's money went into the construction, the maintenance of the property, taking care of children, and running the home, basically. So the courts are taking that into consideration, and that's mainly because mainly the High Court and the other courts now where the appeals are lodged. And I think that's where the courts have been determining the level of contribution, so that after the marriage breaks down, they decide the percentages that each party contributed. So then also in the succession cases, I think the courts have been applying they've been taken into account. Article 27, you will remember a good case which Ngugi did in Kericho, and there were these elderly women who were happy that they were finally inheriting land. So it's a lot of time, yes, to come by, but slowly the courts are developing jurisprudence that deal with that. And then I also found a case that I can share later, and it came from Lady Justice Rawal when she was in the High Court, and that was during the old Constitution, and she was interpreting, I think, Section 35 of the Law of Succession Act, and the way the Law of Succession Act was not supposed to apply to the pastoral communities. But she made a bold move under the old Constitution and said the land the property of the person who had died in Narok did not fall under the exclusion under the Law of Succession Act, and the daughters could also inherit. So there is progress, jurisprudence is coming from the courts, but you will appreciate that not many cases come to court. So there'll be other instances where people are not aware, the women are not aware that they're supposed to own land, that they're entitled to land, and that they have rights to, they have access to justice to lay claim to their what is rightfully theirs. So there's need for lots of education, but for the cases which are already coming to court, the courts are looking into that. But the other area that I think will need some addressing, Professor alluded to the issue of land being held in trust. What we're seeing in communities like Mr. Njoroge referred to, like in Embu County, so you have the Mbere, and most of the land was registered as community land or under clans. So now when adjudication is done, we have lots of cases coming because, as usual, the men want to exclude the women from ownership. And when you go to Samburu, I was handling Samburu until January this year. In Samburu, there's a case I did, Ngari Ranch, now I can discuss it because it's out of my hands. And you had minutes where the community leaders sat and said they were going to register members. And the people who were not supposed to be registered as members of the community for purposes of being allocated with land were women, where they are widows. And where they are widows and their husbands were already registered members. Remember, this is the time they're registering. Huh? So through that, you end up excluding very many women. And the problem is that when they come to court, we look at registration as a very critical element in terms of land ownership, control of land, because it is registration that conveys seal with the land as you wish as a proprietor. Thank you.
your capacity is
ownership, and the role of mediators. Yeah, and we have a lot of mediators in the room. I have seen some whom I know who have been very supportive of the court annex mediation. You know yourselves. And therefore, I'm asking quick comments on those issues and how mediation can impact positively. Maybe we can start with Professor.
I think I can speak in context of what I have witnessed, and it's the speed first and the salvaging and protection of familial relationships in cases of complex disputes. As Eunice, you know, by the time we were joining law firms, we would get files that were from the 70s, and you find that 20 years later they are still going on, and you find that whether court annexed or community level mediation is able to bring this to a close quite favorably, and therefore it removes the problem of almost generational problems and mistrust and hatred that is quite severe. And it is able, and I've seen this work, and it is able to salvage and actually over time restore trust and relations, which are very key at household level. I think to me that is one of the biggest wins, and I can speak to it because I have actually seen it work. You may not get everything you want, but life is often much more complex than that one issue you don't get. Thank you.
Thank you very much. Honorable Baraza.
Thank you very much. I think mediation is good, and I echo what Prof has just said. It mends relationships. It is faster. It provides a safe space for the parties to ventilate. And more often than not, the disadvantaged parties, the voiceless parties have been women. And I am a mediator also, so I know it works. But the most important thing is that it brings the parties who ordinarily would never have sat together, and they can talk about this big issue of land. And some have very good outcomes. So it is something that we should encourage. It is a good complement to the court process, and it produces results. But from where I sit and what I'm going through, it's not just for resolving the land disputes. I think it's for mending relationships. The families are broken in this country. They are broken completely. So if we get a process where we can get land, but also mend relationships, I think mediation is an important aspect in this process. Thank you
so much, Mr. Njoroge. The families are broken in this country. You can weigh in on those issues.
Yes, thank you. And I totally agree that mediation in its very nature being a facilitative process and very inclusive of the parties is the best way to resolve this issue of the inequalities of the women's rights in land. I always tell that when these litigants say you'll have their day in court, there's never your day in court. You never have the time to come and tell the court your story. and everything that you want to say. But I always advise that in mediation, we have all the time to sit down and listen, you whine and unwind and cry and get back, because we are mediators. And I want to say that we also have a very good crop of mediators who do a wonderful job. Makofi kwenyu. Now that we have found that mediation is the best, we need to go to the next step. And I want to draw examples from 2 countries. In Tanzania, we have what we call the Tindiga Ward Tribunal. That is a mediation tribunal. They have made deliberate, positive, affirmative action to ensure that in the panelists, there is a woman. Mediation already creates the safe space. Put a woman in there, it will even make more safer. The second one is Rwanda, the Abunzi Committee, tribunal committees, which are also mediation. They have made another affirmative, deliberate, positive action by stating whenever there are disputants and there is a woman involved, they are given the first right to talk. Isn't that awesome? So these are some of the steps that we can take, and also spreading the word, the gospel about mediation. We need to have mediation clinics. We need to have awareness in barazas, in churches, in our faith-based places, just to spread the word about the goodness of mediation, because mediation clearly is the process of the parties. Thank you.
Thank you. And now, as we wind up, allow me to request Professor Mbote to come in and share with us, again, very briefly. And you apologize for asking the professor to state things briefly. Best practices. We have heard about Tanzania and Kigali. Any other best practices, even in Kenya, because I'm sure from where I come from, there are some best practices, but because it's not my day to speak, I'll let you share some best practices.
You know, I don't want to talk about best practices because I can't beat Council Njoroge. What I'd like to say is mediation is the way people resolve disputes. And if you remember, in many communities, taking people to court is throwing them to the dogs. So you would have tried to deal with them, and then if they seem recalcitrant, you throw them out there. So maybe we need to invest a lot more in building mediation skills in communities, in families, to avoid familiar disputes going out there. Because mediation maintains relationships, and it looks at the future. It looks at how will I be with this person. But when you appear against each other in court, there is a sense in which a wall is erected. And it is up to us, I think, as people in the justice sector. I'd like to problematize, though, the issue of saying we have a woman in the panel, and to look at the whole question of women in law. Law is innately male. So we may have women who are justice actors, and we all need to ask ourselves this: do we bring women values, or are we men in skirts?
That's a heavy loaded one. If you're a man in a skirt here this morning, that's a heavy loaded one, Professor. And I think it's a big punch for the 1 minute that you had. Allow me to end this session